So, welcome. Hello, everyone. My name's Martyn Redstone. I am Head of Responsible AI for Warden AI. And today we're going to be tackling what I think is the biggest regulatory blind spot in the staffing industry right now. California's new automated decision-making technology rules, or ADMT for short. Just to very quickly introduce Warden, we are a continuous third party assurance platform that helps the staffing industry, recruitment technology vendors, staffing agencies, RPOs, and enterprises in managing their risk, specifically relating to AI bias. That's about as much as you're going to get from me from a sales perspective, but I'd like to hand over to my guests so that they can introduce themselves as well for the benefit of you. Let me hand you over to Liisa to start with.
All right, Martin, thank you again for including me in this program. My name is Liisa Thomas. I am the office managing partner of the Chicago office of a law firm called Sheppard Mullin, Richter and Hampton, Sheppard. And I split my time actually between Chicago and London. I lead our privacy and cybersecurity practice and focus right now a lot on artificial intelligence, generative AI. Quantum computing is not far behind. So that's me in a nutshell. And I should say that in addition to my law practice, I also teach at Northwestern Law School. And what usually comes out in these programs, it becomes very clear that I am also a mother. I have two teenage boys that often becomes quite clear as we progress. So that's me.
Excellent. I'm looking forward to seeing how that's going to become clear when we're talking about this, but that's one to look forward to. Thank you, Liisa. Over to you, Ram.
Thank you, Martin. Good morning, everyone. My name is Ram. I'm the CTO and one of the co-founders of Sense Talent Labs. Sense offers a platform that helps staffing firms improve their recruiting processes through AI-driven automation and engagement tools. So some of the tools that we offer are AI-driven sourcing and matching, AI-driven workflows for automation, and voice and LLM-based conversational agents. We use Warden for our auditing use cases for bias and compliance with AI regulations. And I live in San Francisco and have three young kids, three under four.
Oh
Wow,
boy.
3 under 4. I'm only saying that as I'm a parent as well. We're all parents. I've got two daughters and I live in London, UK. Excellent. So a couple of housekeeping rules before we kick off. First one is for those people who are attending live, we have a Q&A button at the bottom. So if you want to ask a question specifically to any of us panelists, then feel free to use that. There is a chat option as well. However, sometimes I find that if you're asking a question in the chat, it does get lost. So make sure that you're using that Q&A if you have any specific questions. I will also make it very clear that this session is strictly for educational purposes, and at no point does this constitute legal advice. And that's all the housekeeping I have for today. Automated decision making technology, CCPA. These rules took effect in January this year. And while the industry has been quite distracted by all of the hype around generative AI, these regulations are, and we're seeing this across the kind of the regulatory matrix across the whole of the US really, is that they're coming for the tools that staffing and recruitment teams are using every single day. Vendor management systems, ATSs, chatbots, you mentioned earlier, Ram, that you have kind of conversational tools as well. So before I hand it over and get really deep into the conversation, I'd like to take a quick kind of temperature check of the room and launch our first poll of the day. I'm looking around for the poll setting, seems to have disappeared, which is interesting. Sorry, bear with me for one
Yeah,
second.
and I don't see it either.
Oh, there it is. Sorry,
Okay, good.
I've got it. So there
Okay,
we
good.
go. Yeah, so I've just launched a poll for everybody to answer. And so you can see that in front of you. So we're asking which scenario is the biggest risk to compliant AI adoption in your staffing firm or recruitment team right now? Is it your commission structures that are rewarding poor practices? Is it automation tools that are auto rejecting candidates to keep dashboards clean? Or is it legal policies that have been written for you, but you might never follow? Interesting to see your answers here. So we're just going to give you another 30 seconds or so to get those answers in. It's looking like an interesting response to this, that's for sure.
We're on pins and needles because only you can see the responses as they're
Ah,
coming.
well, once I end it, I can absolutely
Yeah,
share it.
don't tell anybody because you don't want to influence anyone's answer.
No, that's fine. That's absolutely fine. It looks like we're there. So I'm just going to end that poll and share the results. So hopefully everybody can see this on their screens now. So yeah, so it's looking interesting. We've got obviously in third place commission structures that reward speed. In second place, legal policies that are written but are never followed. But in first place, unsurprisingly, automation tools, auto rejecting candidates to keep dashboards clean. So, Liisa, Ram, what are you taking away from these results?
The way I think about it is, as a vendor, we can help quite a bit with any one of those three, but especially two. We want to build into the products that we serve the necessary workflows and tools to be able to incorporate within agencies' processes the decisions that went into effect regarding things like auto rejecting a candidate. What we worry about more is this changing landscape and framework of compliance laws that are happening all throughout the country and throughout the world, and making sure that we're on top of them, but also our customers are aware of them and on top of them. And the technology is moving towards being able to serve the customers in those ways.
Yeah, superb. Excellent. Thanks, Ram. And Liisa, to bring you in here, we often treat new regulation just like a checklist for our legal team just to get through. But one of the things that we talked about before this webinar and when we were doing our prep was how AI compliance is a fundamental kind of organizational change challenge. And when a staffing firm or recruitment team is trying to roll out these new rules, how much of the friction comes down to cognitive bias? And when we look at these results, we think about fear of losing commission. How do you overcome the reality that the purpose of a system is just what it actually does in practice?
Yeah, so many questions. Okay, so I think to start, you asked for reactions to the quiz and the results of the quiz. So I'm going to start there and say, and I'm then going to transition to your question that we often find this in practice. And I was actually teaching class last night to students who are in Northwestern's program that is a 1 year law degree. It's a 1 year law degree. So instead of becoming a practicing lawyer at the end, you add that sort of law knowledge to your existing practice. And it's a really great group of students because you have people who have come through and they're adding this on to their undergraduate degree. And then there were students in there where I just celebrated yesterday my 25th wedding anniversary, which I spent yesterday.
Congratulations.
Thank you. I spent teaching class, but there were two people in the class who had celebrated their 30th wedding anniversary. So you have a wide range of folks. And so you really get reality in the room. And I think one of the things that's hardest in this space when there's so much going on is there's so many questions, and we are prone to combine all of the issues. And so that was one of the things that I noticed when you asked this quiz is that you had shared with us the questions you were going to ask before, but I was really struck by when we saw the answers, I really wanted to ask people, was the worry that you had about the adoption of AI or that the AI was being adopted in a compliant way? And I think those are two different things that
Yeah.
sometimes get conflated. So to lead that into your question about how do we get adoption of tools, these AI tools, especially as they are changing and our use cases are changing, and we don't even necessarily know what the use case is going to be when we first see the tool, or the tool has one set of features and then tomorrow it has different. We were joking about Zoom keeps changing on us. These tools change all the time. Is how do we approach that as from a compliance standpoint? And so I sit at the intersection of law, so I am a practicing lawyer, but I also have a master's degree in organizational change. So a lot of my answers today go back to that. And I'm trying to pull in being a mother. And I have boots on the ground knowledge of trying to get kids to do things that you don't want to do. And Ram, it doesn't change. Like when they're over 4 or under 4, it really doesn't
Everyone
change.
says it gets better at 5, but it sounds like it doesn't, huh?
Well, yeah, sure. It does. It gets better at 5.
We
Yeah,
believe you,
whatever
man.
that person said. So I think when we're approaching compliance and we're approaching the legal requirements, and I will put in the I don't know if I actually can put in the chat, but I can share with folks afterward. There's an article that we wrote about this particular law. You can't see it, but above the pictures in the background, I have all of these treatises on all of these different laws. They're thousands of pages long. It's really complicated. They're changing constantly. And so I think we can simplify it down to two pieces. One is the organization that we're trying to change is a system. And Martyn, you mentioned the purpose of the system is what it does. We need to have that hat on when we're thinking about compliance. So an example, so there's an acronym for this, which is POSIWID. And there's a recent book by Dan Davies that I highly recommend. The name of the book I have forgotten. It has something to do with organizations as systems, but it's a great book. It came out a couple of years ago. And in it, he delves into this concept of POSIWID, but it's you mentioned the rewards. Have we set up a system that by its very nature is not compliant? And sometimes we could ideally, we set up a system that by its very nature is compliant. The perfect example for anyone who's traveled recently is when you go up and you find that you've been bumped from the flight, or you're standing behind someone who's having a meltdown because they've been bumped from the flight. And the gate agent says, "I'm sorry, sir, there's nothing I can do." And he can't do anything because the computer is set up to put frequent flyers on the flight and to bump people off the flight. He can't do anything. That is the purpose, is to reward those frequent flyers, and he can't override that decision. So that's one. And the second is that within the organization, there are people. And so we often forget that when we are asking people to change, we are running into their fears. Will I lose my job? Will this change the way my job works? Do I have the skills to do the job, for example? And we're also running into cognitive biases. So I got to get this done. I got to move on. And one of the things, and so I'm just going to keep clicking the link because I got to get this thing to work. And so there's interruptions that we can create for cognitive biases. And Ram, I will do this for your kids under 4. To the extent that you have been looking at Montessori schools, you have heard the prepared environment. So we try and, from a compliance standpoint, can we create a prepared environment? Do we train people about not clicking links, or do we put more effort into ensuring that they don't get the bad links? We've created a prepared environment that is safer for them. So those are my answers to your big question, Martyn.
No, suppose it sounds very much, do we treat the symptom or do we treat the cause ultimately? Yeah. And yeah, it's always a very interesting decision-making process around there, isn't it? Excellent, excellent. Look, I think that's a great pivot to talk about the system and the technology itself. And actually, before I bring you in, Ram, to talk a little bit more on that, do have a second poll. And I think that it's a good one to run before we get into the technology conversation. So hopefully I can work out. Yes, I can. Excellent. So the second poll I'm just launching now is asking our attendees, do you know exactly which tools in your current stack use automated decision making? Yes, I know all of them. I know some of them, or don't know any. It's a black box, to use a phrase du jour. We'll just give our participants a few seconds to give them an answer, and then we'll get into the next part of this conversation. Ram, while we're waiting for those results to come in, Let's talk a little bit about the tech stack, shall we? Because staffing firms, yeah, and recruiters, as we know, they're using AI for everything now. And from a vendor and CTO perspective, how are you classifying kind of high risk versus low risk AI? And specifically, and great to hear it because of your CTO position, where's that technical line between automated decision execution and a regulated significant decision like scoring candidates and what have you?
Absolutely, and I'm happy to get into that. I just wanted to add one thing on Lisa's point, which will flow into your question. She brings up two excellent points, and I think that there's a third one related to it, which is that these services and tools are really powerful and already very useful. They speed up recruiters' productivity. So then there's like, when you have an organization, there's a wide variance of the employees, recruiters' willingness to adopt these. Some of them are going to treat it like the Wild West and adopt it really rapidly, and others are going to not know what to do and be more cautious and take a step back. And I think that as the regulatory landscape is forming, best practices are starting to form, but they're not cemented quite yet, right? And so, like, when you get into the details of these regulations, it's really helpful to step back and realize that there is a lot of usage of automation across recruiting stacks, from tools within the ATS's sourcing platform, CRM tools, and more. And these systems already have quite a bit of AI capabilities already built into them. The challenge is, what is the differentiation between the ones that are just making recruiters more efficient in terms of just working faster, but not making fundamental decisions, versus ones that are materially impactful to the decision-making process. And that distinction is not always necessarily apparent or visible to the entire workforce within a firm. So as a vendor, it's imperative that we help provide that clarity, especially around how our customers use our tools to be able to understand that. I think the standard real definition right now for automated decision-making technology is this high risk, low risk AI designation. And the way that we define it is, high risk is anything that has impact in, it has or may have an impact in the candidate during the recruiting lifecycle, specifically decision-making impact, scoring or ranking candidates or applicants, which may lead to some candidates being prioritized over other candidates. Automated screening definitely would have that type of impact, and the output of that screening and how that's used, whether that's AI-based evaluations or algorithmic evaluations. Categories of low risk could be things like pure productivity tools for recruiters. For example, generating job descriptions that just makes it faster. Instead of it taking 2 hours to write a job description, it can be done in 5 minutes. Or scheduling a call or calendar coordination, generating outreach. I think one of the real risks and nuances, though, is there are use cases where it seems low risk, or it starts off as low risk, but then transitions into high risk. Resume parsing is a great example of this. ATSs have had integrated resume parsing for decades at this point. But now that it's so natural and integrated and useful, it's very easy to then just add a rule, add an automation that says, okay, these are the resumes I want to be able to do X, Y, or Z with. And that's where now in this new landscape, you have to really think about, what does it mean to introduce those types of processes within your recruiting funnel? And then how do you ensure that your team is compliant in the way that they're using those types of tools?
That's fascinating. Actually, it really makes you think. That example about resume passing is really interesting. And actually, I'm going to share the results of the poll now, because we've got 50% saying, yeah, they absolutely know where in their current stack they use automated decision making. And actually, I think if you were to then, based on what you said, go back and re-ask that question, I think we'd probably get a slightly different answer to that. So I think that example of resume passing, super interesting, Ram. What do you, in terms of Sense's conversations with clients and looking at the results of the poll here, what are you taking away from this?
I'm sorry, could you put the poll back up? I had actually
Oh,
closed it.
hang on a second. Let me see if I can redo that. I think I
Or
found.
you could just tell me what, I know that the top one had the most.
There we go. Excellent.
Yeah, so then this
Although
yes.
it's close. It was
Yeah.
close.
Yeah.
It was close, yeah. I think that there's a lot of nuance. So, you, the way that I think about this is, at first glance, the obvious stuff is obvious, right? If something is a voice agent that's doing the entire screening and then saying this person should be moved to the next stage. That's clear decision making. But what we end up seeing is things like all the underlying components that go into individual pieces of extracting information from a resume or taking the notes that a recruiter wrote and then saying that this is what we expect the availability of this candidate to be. So instead of reaching out to them now, reach out to them at this time frame. All of these things, they're starting to form a soup where the distinction becomes more and more difficult. What is the constitution of the soup? And I think that from my perspective, I would be in that some bucket because I think that these definitions are getting more and more complicated to draw super clear boundaries or lines around. There's also an aspect of it is what is the processes that a particular organization can put in place to be able to like help define these boundaries. So an example is if every candidate, while have a prioritization mechanism that uses automation or tools for it, still has to talk to a recruiter. That distinction is really not only a pure technology distinction, but it is a process and decision making within a company's decision.
Yeah, going really back to what Liisa was saying earlier about building the system around it or treating the cause, treating the symptom. I think that's going back to that example again, really, isn't it? And I think the thing that I've taken away a lot from this new regulation is that, as you alluded to, is that this is almost looking at the stack of technology as a kind of decision-making stack, starting right at the beginning, like you said, CV parsing and even earlier potentially, and who is being given an opportunity and who, more importantly, is not being given an opportunity. I think that this is, like you said, I think this is causing. I love that example of a soup. It's absolutely feels like that sometimes. Absolutely does. So I'm just going to turn this poll off from in front of me so I can actually see what's going on my screen. There we go. So moving on a little bit around the requirements of the CCPA, I want to tackle that a little bit more and specifically opt-outs, because the CCPA says that consumers have the right to opt out of these automated systems. And operationally, that sounds like a complete nightmare for a recruitment team or a staffing business who are processing thousands upon thousands of candidates every month, every year, and getting more and more. Liisa, coming back to you on this, is there a legal threshold here? So if a candidate says, no, I don't want anything to do with automated systems, what kind of alternative process does the law actually require?
So I'm going to go back to your caution at the beginning. This is not legal advice.
Absolutely.
We're going to double down on that one. So first, we have to think about the laws as we're moving our analogies from soups to patchwork. So we could spill the soup on the patchwork, or I don't know how we could combine those analogies. But with a law like this California regulation, parts of which go into effect in January 2027. We're still working on understanding what we're supposed to do. It can't be looked at in a vacuum.
Mm-hmm.
So there's already existing requirements. And so the way that I like to walk clients through is to think about the legal requirements around a system or around the use of a tool have to do with the inputs into the tool. Are we putting in personal information? Then there's going to be privacy laws, data security laws. Are we putting in creative content, copyright infringement issues? Then there's outputs. We're really focusing in this conversation on outputs, the bias. So when we're talking about giving people choices, we're talking about letting them opt out of potential systems that could result in bias. That is, as you point out, a really big lift. And so what I think about is going back to Ram, your example of it starts out as one thing, it starts out as low risk, and then it ends up as high risk. I think this is where compliance and legal are historically the disaster in the room, because we are the mom that is like bringing things down and everybody's running to dad to ask dad because we're like really bringing the mood down here, because we ask the question that a lot of these laws are triggered on, which is, how are you going to use this? And once you tell me that, then I can tell you what the legal requirements are. But we don't know how we're going to use it. And so, Ram, in your example, we're putting something into the system, and then later we realize, you know what? We used it for this purpose, but it would be really helpful for this other purpose that we didn't understand and we didn't realize. And so now you come back to the lawyer and you say, can we do this? And the lawyer says, did you tell people you were going to do that? And it's, no, I didn't tell people I was going to do that because I didn't even know that I could do it. So when we're thinking about that, I like to go back to unfair and deceptive trade practices laws, which are usually where we see enforcement action. And for folks that like to subscribe to blogs, I write about recent developments, and there's a blog that's called Eye on Privacy that I write. And there was a recent case where it's just been filed, it hasn't been decided. We're going to see what happens. But the idea was use of AI, not what law do we use to say it wasn't right? Because we don't necessarily have an AI law that says it's not right. Let's use what you were doing was fundamentally unfair. What you were doing was deceptive, which is very annoying when you've been sued under that theory. But I think when we're trying to decide what we're going to do, it's a helpful framework, because we can say, would someone think that what I'm doing is fundamentally unfair? Or would someone think what I'm doing is deceptive? And if so, what systems, how can I set this system up so it doesn't end up with an outcome that's unfair or deceptive? How can I set the processes up so the people within the organization are helping support fair and not deceptive outcomes? So when I think about that piece, it's obviously going to depend on the situation. You asked Martyn a very specific question. As a lawyer, then of course my job is to ask a question back, which would be, in this situation, what would we do if we weren't using the system? And the people are going to come to us and say, that's like, I'm so embedded in the system that there's no way that we wouldn't use the system. And part of my job, I mentioned I am a privacy lawyer, but also a cybersecurity lawyer. I deal with data breaches all the time. I can promise you that there will come a time when the system, this automated technology computer system that you're relying on, isn't going to work, because it's going to be breached, because the third-party tool that it is running off of, maybe not the actual tool and the vendor that you're working with, but the vendor's vendor, right? Was it like a month ago that Outlook had a shutdown, right? There was a hiccup and everybody slowed down. So I asked the same question. It's called a pre-mortem, right? Let's presume it fails, the system that we're relying on. What would we do in the absence of that system? And I think that question can help answer a question like what you posed, Martyn. If someone came to us and said, I don't want you to be doing this, what would we do? We better have an answer to that, because separate and apart from any of these laws, if we had a breach and we can't, and again, it wasn't ours, it wasn't our vendors, it was the vendors. If we don't have a workaround, that means that we're not engaging in those business practices. And that means that potentially work is stopped for some period of time that's outside of our control. So that would be the question that I would answer your question with.
No, that's great, because I think that's a great kind of takeaway for our audience today, is not only asking the question of what do we do, what do we offer, but actually you're quite right, because there should be redundancy there. There should be the ability to not have to rely on the systems, and therefore that is logically the alternative that you would offer to somebody anyway. No, I really like that. It's a great way of pointing and signposting our audience in the direction of asking those really important questions internally to cover off not only something like this, but also some very central business processes as well. So thank you for that, Liisa. Ram, just passing this on to you, just thinking about Liisa's mentioning about kind of building systems and what have you, and obviously that's what you do. How would you it because obviously we, like I said, we have to be offering the opportunity for people to not be subjected to the automated decision making technology. And Lisa's quite right in terms of that has to be part and parcel of your business operation anyway to have that available. But how do you build that kind of giving that option into the UI, into the system? Are you thinking about that at Sense?
Absolutely. At the forefront of every new product capability or product that we build. I really like that Liisa touched on what she called the concept of a pre-mortem, because it not only for us, but also for the staffing agency, it puts in the forefront of their mind what the possible failure scenarios could look like, but also what do they need to do to ensure that they can avoid or minimize adverse events in those failure scenarios or try to prevent them from happening in the first place. The way that we think about it, we want our platform to be flexible. What's important is being able to provide the tools to set up a process that's actually going to work. And what I mean by actually going to work is not only does a candidate have the ability to provide their intent, their opt-out request, and that it's honored, but the staffing firm is also set up to be able to act on it. And there's clear delineation of that the decisions that were made, the traceability and the auditability, so that the staffing firm also has the ability to communicate exactly how they were able to comply and honor that staffing or that candidate's request. So, like, how does that actually manifest itself within examples in our product? For example, our voice screening agent. We have templates for how we believe that call should go, and then those templates can be configured based on a particular customer's hiring needs or job domain. But at the beginning of every single one of them, it's very clear that the voice agent communicates that it is a voice agent that is powered by AI. It's intended to be used in this fashion and asks the candidate for consent to be able to use it and continue on with the conversation. And we handle a wide variety of different types of responses from that, from like obviously yes to no, I want to talk to a recruiter, or I'm not comfortable with talking to a voice agent, or they might even start with it saying yes, and then you have to handle it at some point, them revoking consent and also not penalizing them. So all those different types of scenarios need to be thought through, and we try to meet the end user, the candidate, where they're at to be able to ensure that they have that control and ability. The voice agent is one where it's real time, so it's a little bit more direct. That those opt-outs, we capture them, we act on them within our own platform, but we also provide a record and traceability directly back into customers' ATSs so that they can not only recognize that it happened, but have a record, do what they want with that within their own systems of record. Yeah, and then beyond that, from the standpoint of candidates that have opted out, we provide automation capabilities to be able to direct those candidates into different workflows, whether that's an email directly to the recruiter, an ATS task, an SMS to the recruiter. We have a messaging system that like communicates between the recruiter and candidate via SMS, or a scheduling link to be able to call the recruiter directly. The tools that we want to provide, they need to be able to meet the staffing firm where they're at in their hiring processes to ensure that they feel confident they're going to be able to act on their requirements for meeting those regulations.
No, that's excuse me, that's excellent because my kind of follow-up question was going to be how do you make sure that those that opt out don't fall into a black hole? But you've preempted that question brilliantly, and I think that just goes to show that you have to think about the path for each of those options and make sure that it's, like you said, meet them where they are and make sure that's as accessible and as engaging as possible still. But actually it brings me on to the next kind of thought process that I wanted to talk about, which is about liability. Because something that I hear quite a lot from recruitment leaders, from staffing leaders, is that they're increasingly starting to act as product managers. They buy a third-party tool from a vendor, but those tools tend to be highly configurable. And so the recruiters end up configuring the rules and configuring the thresholds. Liisa, coming back onto you, if a staffing firm or a recruitment team is configuring a vendor tool and that tool then makes a biased decision, who's liable in the eyes of the regulator?
Okay, so Martyn, I'm going back to your original statement, which is this
Absolutely.
is not a legal opinion and it's not legal advice. And I also you put fear into the heart of a lawyer asking these very targeted questions. It's like you've become a law school professor. We can't look at this in a vacuum either, right? So we're talking about, and the topic of this is under this particular law. And this is, again, I'm going back to the exercise that I made the students do yesterday. We were talking about telemarketing, but it's the same concept. There are millions of different laws that could apply. The answer to the question is going to be very narrow. We have to understand what is the jurisdictional scope, right? We've got the existing New York City law. We're talking about this law that isn't yet, like, we have to get in compliance with it by 2027. I think in the apps, what is a good rule of thumb is, I think, what we can do for this is what I generally use when I'm trying to set up, like, how am I going to approach this? A good rule of thumb is, what would you tell your mother? What is the story that we're telling here? And so if I am adopting, and Ram, you alluded to this earlier, if your client is adopting a tool, you can't control how the client uses the tool. And I will, the dumb analogy I usually use is Microsoft Word. Microsoft can't be liable for someone using Microsoft Word to do something that's illegal. And so the company that's adopting the tool has to take the responsibility that all of their mothers would expect, that they're taking the responsibility for their own actions. Now, where it gets more complicated is, to what extent does the company understand the tool enough to be able to overcome the bias, mitigate the bias? And this is where having these conversations, I go back to a pre-mortem. So this is not my concept, by the way. It's Harvard Business School thinkers. You can search pre-mortem. It's an HBR thing, not a Liisa Thomas thing, although I'd love to take credit for it. And we can think about, are we spending time thinking about the outcome and sitting down with our business partner and thinking about the outcome? And I unfortunately witness all too often, we move very quickly and we're really focused on achieving a goal. The goal is, we've got to launch this by X date, and we don't really think about how are we using it. And I mean, as I get worried when I am asking the fact questions and they're questions that folks in the room haven't thought about. I shouldn't be asking the facts questions. I'm just a lawyer. You should be coming to me with the fact questions. Obviously, I am a business partner. I work with my clients all the time. I've seen deployments where they've never seen the deployment before. But I do think that when we're faced with something new, we sometimes let go of asking those critical questions. So shall I use, Ram, have you gotten for any of your kids to the point now where why is their favorite question? Why? My mother's favorite story about me was, I always asked why, and she turned around in this car and she like leans over and she's, Liisa, if you say why one more time, and my mother never threatened me. And I still remember this, and I was probably around 3 or 4, and she said, don't say why again. And I said, how come? So please use the why. And if the why isn't accessible, ask how come.
Brilliant. Absolutely brilliant. Love that story as well. I'm just hoping that my kids don't see the replay of, yeah. But that's brilliant. And it really does open up exactly what we're hoping that people can take away from this, which is thinking about the operational implementation and asking those questions, those whys and how comes. And actually, Ram, from your side, from the vendor side, we go back to that kind of liability relationship. How do you view that relationship? What's your responsibility as a vendor to provide kind of transparency, to provide audit data so that the staffing business, the recruitment team, they can protect themselves as well?
Yeah. I like the fact that you mentioned that these systems, they're highly configurable and adaptable to how particular companies, firms need to leverage them within their recruiting processes. And firms will use multiple different services, systems, technologies, right? So yeah, it absolutely has to be a shared responsibility between these vendors providing the technology and the firm or agency configuring how they're actually using them and how their staff is using them. From the vendor side, it's critical that we provide transparency around things like the documentation related to what data is used, how that data is used algorithmically or through AI decision making, providing the tools within the platform for the explainability of what just happened. For example, an assessment or evaluation happened, making sure that it's clear what the criteria was and then what the outcome was is an example of that. Providing tools so it's easy for candidate requests to fix or update data can propagate through and actually impact forward going uses of the platform. These are areas that we absolutely think about and introduce or work towards introducing within our platform. And then things like oversight, bias audits, and processes for continuous monitoring. But we can provide all this stuff. At the end of the day, the firm has to make sure that they're leveraging it and using it. And then that KT is happening throughout their organization to make sure that the individuals using that within the organization know how to answer questions that might come up, as an example, from a candidate, and make sure that those answers are accurate to like how the system works. So it's absolutely a shared responsibility.
Yeah, absolutely. And it absolutely reflects what Liisa was saying as well. Ultimately, I love that Microsoft Word example from Liisa as well. But you can take a horse to water, but ultimately it's up to them to drink from the pond.
I was just thinking of my analogy, and I want to shift it a little bit
Yeah.
that when you are in the position of purchasing one of these systems, one of these platforms, I think the question becomes, can it do multiple things? Some are good, some are bad. Or the POSIWID, can it only result in a bad outcome? And it's unusual. I can't think of an example where a system like ROM's could only result in a bad outcome, but that's really from a legal perspective where you might see some of the liability shift.
No, great, excellent, excellent. Thank you, Liisa. So we're coming towards the top of the hour. It's gone so quickly, but I take that as a good sign. There's some questions coming in, but I'd like to give the audience an opportunity to get any questions they have in now. And while they're doing that, it's just been incredibly insightful, actually. I want to think about some practical takeaways. So, Liisa, for the people on the call today, what are your 3 practical steps that they should do tomorrow to start operationalizing this change?
I had 3. Now I'm going to have 5. The Montessori environment and the why. Like, I feel like you got to take the Montessori environment and the why. But my 3 were looking at the system to avoid accountability sinks and the system running the decision. So try and have good POSIWIDs, not bad POSIWIDs. Remember that people have an emotional reaction to change. So if we're trying to change things, we've got to deal with that emotional side of it, or else people aren't going to change. They're just going to nod and not do it. And I think that was one of your like examples in one of the polls was like legal says we do it and we don't do it. And then I think the last one is just be willing to be creative. Like these things are changing all the time, and you've got to understand and admit that they're going to change all the time, and that's okay.
Yeah, love that. Yeah, that last one's so important. Just be open to it. Absolutely. Ram, same question for you, really. What are your kind of three key takeaways? What are the three kind of technical or kind of vendor focused steps that businesses need to take pretty much immediately?
Absolutely. This can be a very complex area, right? I like to think of it like security. Security can be so complex for an organization, and it's impossible to always know every single possible attack vector out there. Part of the way that I think about it is this is a risk management strategy, and how do you minimize the risk, maximize the effectiveness of your organization using tools like this? I think you have to start with very tangible things that you can do that have a clear delineation of this was implemented, it was done properly, and it's useful and or effective, right? The three that I would do is mapping your recruiting tools and all of the automation and AI features that your organization is using across your technology suite, right? Then categorizing them into assistive or decision making based on your best understanding of how your organization is using them. Then getting vendor transparency documentation from all the vendors regarding their AI features, how they're used, what data is going into them, any algorithmic considerations. And that's where you can go deep and ask questions and make sure that you have a strong understanding of that. And then when you start implementing or using them, design these compliance flows directly in as a first principle in the usage of them. So opt-out workflows are absolutely critical, making sure that you have access to the audit trails, and there's a review process for turning these things on in your organization.
Excellent. No, so really actionable points there. It sounds like people need to get their information gathering into order immediately by the sounds of it. We have one question which has come through. So I'm going to ask the question and I'll probably come to Liisa for the answer, but Ram, feel free to jump in as well. This said CPPA, but I presume it's CCPA regulations have exemptions for opt-outs. In quotation marks, ADMTs that are solely used for hiring are exempted from the opt-out requirements, provided that the system works for its intended purpose and does not unlawfully discriminate based upon protected characteristics. So that reads like specialist HR systems are okay to use if they're used as appropriate and do not discriminate, but general AI tools, e.g., LLM chatbots, are not. Does choosing a specialized vendor mean I do not have to provide an opt-out?
It's not legal advice, folks. But I would, and I would love to talk to whoever asked this question. We can't tell. There's probably a lot of facts that go into this. I would give you the same advice that I gave to my students yesterday evening, which is you really need to look at the law closely. There's two parts to that exception. One part is that the ADTM works for the business. I'm looking at the law. The business's purpose and does not unlawfully discriminate based upon protected characteristics. But the first part, that's section 2B, section 2A, is that the business uses the ADTM solely for the business's assessment of the consumer's ability to perform at work. Consumer here being also covering employer, ability to perform at work or in an educational program to determine whether to admit, accept, or hire them. When I am faced with a question like this, I want to understand more of the facts. Then we have a legal answer, a conclusion about the first part, right? Like, when is it okay? So then we would have to make that legal decision. Have we met the exemptions? And then I would go to the second part of the question, which is, if this is the legal requirement, then what do I do? And I think and I apologize for whoever asked this question because I don't know all of the facts, but it seems like you might have made a little bit of a leap here from taking the requirements and then operationalizing them. And so I guess, Martyn, I'm going to add a sixth step, which is don't rush to solution. Be comfortable with sitting with the problem for a little while. So we have a lot of pressure to come to solutions. That's why people come to us. That's why we have these jobs that we have. It is going to create a better solution if you sit with the problem a little bit. And there's lots of research that shows that you will have a better solution if you sit with it. If anybody wants to reach out to me and get more like evidence, I've got lots of behavioral science evidence that shows that if you sit with the problem, you will have a better solution. And I think the way this question reads, I don't know this person, but the way anonymous, I'm sorry, the way the question reads, it seems like we're trying to rush to find a solution, and I would slow down a little.
No, that's great. And actually, on that point, whilst the laws kicked off in January this year, we have until January 2027 to actually get everything compliant.
Yeah.
Like you said, we've got plenty of time, sit on the problem for a little bit and come up with a great solution.
And ask why. Ask why.
Yeah, and ask why and how come. So love that. And what a great way to finish the session today, because it does bring us to the top of the hour perfectly. Liisa, Ram, thank you so much for helping me bridge that gap between kind of to operationalize these rules. And thank you for everyone who's joined us. We will be sending out the recording of this session as well later this week, probably early next week now. We're coming into Friday. But very quickly, Liisa, Ram, how do people get in touch with you if they want to follow up?
LinkedIn. Liisa with 2 eyes, LinkedIn.
I'll make sure that link's in the follow-up email as well, and also the links to the blogs you were talking about. And Ram, how about yourself? Same with you?
Same with me. LinkedIn is a fantastic way to get in touch with me.
Excellent, excellent. So I'll make sure that both those links are on the follow-up email. Thank you both so much for giving up your time to help educate our industry in this really important new regulation that's come out. Really appreciate it. Thank you everyone for joining us today, and I look forward to inviting you to our next webinar. Thank you very much. Have a great rest of the day wherever you are.